All right, my friends, welcome to another episode of the Josh Scanlon Podcast. And again, I got an exciting, they're all exciting. Let's just admit that. All the podcasts we do are must-see TV, right? But anyway, this time I got Stephanie Scarborough, who's an attorney locally here in Atlanta, and I think also has an office in Florida as well. So if you're a resident in either of those two states, you certainly want to look up Stephanie. However, I imagine you can find her in other ways too, which we'll get into. But I found we spend so much time on investments, and I just want to drop an anvil on my head because the biggest risks are not investments. The biggest risks are improper estate planning. And I've used beneficiary designations a million times a Sunday that if you don't get your beneficiary squared away, it's all for naught. We've had case law where people of second marriages have left money to their previous spouse that wasn't meant to go there, and the judge says, no, that's what you had left when you died. Sucks to be you. So estate planning is a big issue, and then obviously healthcare is another big issue as well. But it's interesting because Stephanie is also an immigration attorney, and I can't tell you how many people I have who reach out to me who have spouses that aren't Native Americans, not Native Americans like the American Indians, but born and raised like your old buddy Josh here in the U.S. So it's my pleasure to introduce Stephanie Scarborough. So welcome aboard, Stephanie.
Thanks, Josh. Thanks for having me. I'm excited for our discussion.
Absolutely. So if you don't mind, just tell us a little bit about you. If it just whatever comes to mind, you like the Patriots and the Bruins or whatever comes to mind. Tell us a little bit about Stephanie, if you would.
Don't talk about the Patriots now. So Josh, I am, as you state, I have been practicing law, immigration law for a number of years. I've actually been involved in immigration for about 20 years, been practicing immigration law for over 10 years. And in addition,
before we got on the line here, I think one of the neglects that people have is their estate planning, because it is a pain. There's no getting around that. And they say, I'll just push it off. Give us some ideas of what you see in your experience. And this doesn't have to be just for immigration, because I know you don't just deal with immigration, but you deal with, good old fashioned, people here in the good old US of A too. But what have you seen in your experience? You've been around for quite some time doing this stuff. So you've seen cases after cases, and anything jump out at you? Not a estate plan that you've done wrong or anything like that, but just an estate that was neglected. You're like, man, I wish they would have done, or I wish they would have listened to me, or any examples that you have where you presented an estate situation that they just did not act, where they could have been they could have been squared away if they just would have done something. Does that make sense what I'm asking you?
Yeah, absolutely. And actually, if you ask me what the biggest mistake in estate planning it is not having an estate plan.
Yeah.
Just failing to act. And they're really not highly complex documents. Yes, it takes some thought, but the failure to act is the biggest mistake that people make. And sometimes by having these documents in place, it can have a significant impact. And I'll give you an example. Most people who don't have, well, I shouldn't say that. People with high net worth even don't have an estate plan, or don't put their money in trust, and don't think about these issues, or think about them and just keep putting it off. And that is really common. Like, they know it's one of those nagging things in the back of their head, but it's hard to think about the end of your life. And also, estate planning generally works for the benefit. The estate plan itself, a will, a trust, those things work for the benefit of the survivors, of your heirs.
Yeah.
But what people overlook, just doing it, they don't do it, or they put it off. And it's not an engine light. There's no engine light. If something's wrong with your car, the engine light's going to come on and say, you need to do this, you need to do this. Estate planning is something that people don't get warned about until something horrible happens, and then they wish they would have done it. So the other thing they forget about is estate planning is more than just planning for your death. It's more than just thinking about when I die, what's going to happen to all my assets. It's more than that. It is planning for your incapacity. So if you're incapacitated, somebody still has to pay your bills. You have people who you want. We're living in the age of HIPAA. Which is the Health Information Portability and Accountability Act. Right? That's that little waiver, that little privacy notice you sign when you go to the doctor, saying we won't give your health information to anyone. But not giving that health information to anyone also means if you're in an accident at midnight, on a Saturday night and your spouse can't find you, then you might not be told by the nurse's station that, that you're there at the hospital, right? Or if you have an out of state family member who calls a nurse's station and knows that you've been in an accident and wants information just to find out if you're there, if you're okay, they can't do that because you don't have a HIPAA waiver on file with that person's name on it. So there are fundamental documents that can help you if you're incapacitated or you're injured. Somebody has to pay your bills. So if you're incapacitated, so you need a general durable power of attorney. Thinking about incapacity, what would happen if I were in the hospital for a week or a month and I needed someone to take care of my life? If you don't have an estate plan with a focus on incapacity, you don't have anybody who can do that because there are no legal documents authorizing that.
Man, that's
so.
No, go ahead.
No, that's the second mistake is don't just think about it as planning for death. Think about it as planning for your life. Your incapacity.
One of the things I say, Stephanie, is death is easy. It's incapacity that's the issue, and yet it's incapacity gets overlooked all the time because everyone's focused on death. If this happens, estate planning, my estate does X, Y, Z. And I always say, but what if you're not dead? What if you're incapacitated? Like you gave the perfect example as people like, well, my wife's a beneficiary. I said, man, but you're not dead. We just established you're not dead.
She doesn't get anything. Yeah.
Exactly. What happens? So that's what else jumps out at you?
Well, the other thing that jumps out at me, and I'll give you an example, is some people use tools like payable on death accounts as like we call it kind of the poor man's estate plan. They'll either do joint tenancy with right of survivorship with their spouse, or they'll do a payable on death account and have that paid off to a relative or an heir that they want their money to go to, and then they think that's enough. But what about everything that isn't in that pay upon death account? And I'll give you here's a story, and this is a story about my father-in-law. Really, my father-in-law passed away in North Carolina a couple of years ago. He had most of his money in a pay on death account to a step grandchild, right? The money had come from his wife anyway, her life insurance or something. And so he thought it was best to pass to the step grandchild. The problem is he had other assets outside of that account, like houses and cars and tangible personal property, his furniture and all of his household goods and a gun and all this other stuff that were not taken care of, and he didn't have a will. Now, who's responsible? His biological children. His heirs, his biological heirs, are now responsible for the estate, although all of the money in the estate, the cash, is going pay on death immediately to a step grandchild, right? So $100 and something thousand goes to the step grandchild. Now the biological children are stuck settling the estate and paying the attorney for probate, and I'll talk about probate in a second, but paying the attorney for probate some $6,000 while all the money is sitting in an account that is gone to a step grandchild who now grabs the money. He's due the money. It's his money now. Takes the money and goes and there's no help with the estate because there's no money to pay the attorney until you settle all of the assets. So, of course, now your biological children who didn't get that pay on death account, didn't get any of the bank accounts, now have to lay out money of their own until they settle the entire estate, which, was quite nominal, by the way. Maybe enough to pay the
that's
a little
crazy.
Bit more.
Yeah.
So when you die intestate, so in the state of Georgia, for instance, if you die intestate, your estate goes through what they call probate process. And it's essentially a legal process where the court oversees your estate closing, the closing of your estate and how the money is distributed. So it's a required process. So, and what we like to say about the probate process is that it's essentially a lawsuit that you file against yourself, with your own money, because now you have to pay an attorney like me to go to the probate court.
Right.
And help dispose of your assets, and a personal representative has to run around. It's quite a hassle. The personal representative has to get your death certificate. That could take a month to get a death certificate. And if there's a mistake on it, it could take 3 months to fix. By the way, that recently happened to a client of mine. So the probate process can be quite long. It can be quite short if you have a small estate in the state of Georgia. You can get out of it, but you're going through a court process when you could have avoided it through proper estate planning, say with a living trust.
Yeah.
So
That's crazy. I can only imagine the biological children are like, man, we're stuck with all this. There's not going to be enough. I mean, it might be enough just to make us, even Steven, but that kid's already, spending the money on friggin' beer and cigarettes. You know what I'm saying? And
22-year-old, you're gone. You're going to party, right? Or whatever you do. And also, this was in North Carolina, and neither child lived there. So then you have to hire a probate attorney. Somebody has to clean out the house. Somebody has to pay for all of that, or you just walk away. But you don't want to just walk away. You want to try to, there are sentimental things in the house.
Yeah, that's what I'm saying. Just walking away. You got stuff in there that's probably your own from when you were a kid. Oh, that's nuts. Exactly.
That's so it's tough. And that's the kind of thing that can happen because, he thought everything would be just taken care of, I guess,
right.
And maybe didn't think about it at all, but it was actually quite complex. It took about 12 months to settle that estate, and that was not a huge estate. It just wasn't. And so people say all the time, I don't really have that much. I just need a simple will. Can I just go online and get a $50 will or something? And the fact is, that's not the case. That's not true because you don't realize the total value of your assets. Number one, that's another mistake people make is they don't know the value of their assets or where everything is, right? They don't have a list of where all of their accounts are, where all of their assets are, where all their liabilities lie. And, not knowing that means that the person who gets your estate at the end, your personal representative or your family member who has to deal with all of this, or even an attorney like me who's dealing with the probate issue, we have to try to figure out where all your assets are and where your life insurance is and hope that, we get it all. So, and that we can find all of your heirs, for instance. So it can be quite complex. That's the other mistake people make is just not even doing anything, not even listing out their assets.
The thing about what you just said right there is one of the reasons I encourage folks to seek a real live human being for their estate planning, because yes, you can make it done. You can do it on LegalZoom or whatever the other ones are, NOLA, I don't even know what they are, but those softwares aren't going to ask you questions or worse, relay personal stories of situations they've seen with their own very eyes. And I don't, and this is I don't know, it's kind of like one of those things, people spend more money or more time by far on like fantasy football or Facebook arguing politics than they would ever on the stuff that actually matters. And so when I say, well, you got estate plan, oh yeah, I got the LegalZoom. And I'm like, when did you do it? 15 years ago. And I guess that's better than nothing, but I'll
give you a story about that too. The Forsyth County, Georgia, probate judge has a story on his blog, that tells the story of a guy who did one of those online or, whatever the disc at the time, probably wills. And that would have been fine. He would have listed all of his heirs who he wanted to get the estate and his tangible personal property. The problem was when he printed it out, he missed a page.
Ugh.
And he missed the page that had the designated beneficiaries on it. He just didn't print it out completely. It was notarized and signed. Everything else was proper. And the judge said, I would have loved to honor it, but this is the danger of not having, and I know a lot of people say this is really self-serving, a lawyer saying you should get a lawyer,
right.
But the reason you get a lawyer is we're responsible. If we make a mistake, you sue us later. We made a mistake, but if you make a mistake and your printer doesn't print out the most important page of the will, the judge can't honor that will. And now it's junk. And now it goes by intestacy. By the way, in the state of Georgia, most people think, I think it's common thought that people say, well, if I die without a will, my spouse will take everything. And then after my spouse dies, it will fall to my children. And that's not true. In the state of Georgia, it's equal amongst your children and your spouse. So if I have 2 kids and a spouse, then my estate's going to be split 3 ways. and it's not going to all go to my spouse. So where most people
wait, hold on a second. So in Georgia, if you died intestate, whatever it's called,
without
your
a will,
husband
right.
doesn't get everything. Half of it goes to the
Correct.
kid. Wow.
It'll get split equally between your child and your children and your spouse.
Let me ask you a question on that, Stephanie. So say you're on the deed, all right? So, let's say your husband's Bob.
Mm-hmm.
We'll say there's Bob and Stephanie are on the deed of the home, and you got 200,000, and say the house is worth 200,000, and you got 200,000 in a CD that's in your name only. Does the 200,000 house go to Bob, and then the 200,000 CD it gets split up between your two kids, or is it? How does that work? You see what I'm saying? Because he's
right. So the CD will get split three ways.
Okay,
generally.
3 ways.
So
Gotcha.
It's your entire estate. So the house is probably held joint tenants with rights of survivorship. So that would pass to the spouse, right?
Okay.
But most likely that's held if it's held that way. Sometimes one spouse may have acquired the property before they got married, and it's only in one name. Now that's a more common issue. Is if you have a house that's in one spouse's name and they pass away, now you have the full value of a $200,000 house plus $200,000 in a CD split between your spouse and children instead of as you intended. Yeah. So the spouse thinks, well, that's okay. At least I have the house and some cash to pay the mortgage because I never worked because my spouse worked. But now you don't have that, right? Because now the house is going to might go to your spouse because that's their share, but they won't get any cash. Or potentially, if the house is only in the deceased spouse's name, potentially all it would have to be sold so that the cash could break off to a child. Like if you have a child who says, "I want my share," that share is in the house. Get your equity out of that house and give me my share.
Right.
So, and and it happens all the time because
absolutely.
When people die, money makes people weird. I mean, it really is a dividing factor, and people want their money because, a lot of people have not planned well, and they just, money makes people greedy. Even the smallest things, a grandfather clock could divide an entire family. If you don't put in your will, I want the grandfather clock to go to Susie, right? It could be a very divisive thing.
I can only see if it's a second marriage too. And let's just say you had your home. We'll say Bob is, your husband, and he's your second husband. I'm just using that for an example. And you had your home before you met Bob, and now now you die, and so it's just your name on the deed, and you really want Bob to live there, but the kid's like, I never liked Bob to begin with. You see what I'm saying?
Right, because that's my step-parent.
Exactly. So screw him. And if we want to put him out to get our equity in the home. I mean, just
let me ask you, or what if that house passes to Bob, right? And Bob has the house, and your thought is, well, once Bob has the house because it was joint tenants with rights of survivorship, then if Bob passes away, then it'll go to my children. But guess what? Bob has Bob's own estate plan. So Bob can designate anybody Bob wants. What if Bob remarries? And then all the money goes to Bob's new spouse, and your children get nothing. So that actually is, it informs why a trust is important if you really are in a second marriage situation, or if you think your spouse will get remarried, but you want to make sure that your children to a previous marriage still take.
Exactly.
Or your children still take, because you do not want things to get diluted to the point. And most people's estate planning goal, is to make sure that they leave something for their children, let's say. If that's your goal, then you need to really think about a trust structure, perhaps, right? And every situation is different. But that's where we see a lot of people really, really thinking about the importance of, say, a trust over just a will-based plan. And same thing with business owners. They may want their business to follow a certain way and hold those assets in trust. But I think people are a little afraid of trusts because they don't understand them. But really, in your lifetime, a trust is just you. It's your social security number.
Yeah.
What a trust does is retitle your assets into this vessel, into like a bucket, this trust bucket. You can change the terms during your lifetime, but when you pass away, it then falls outside of your estate, outside of the probate process, no court, right? If you've funded it fully, and then it falls down to your heirs the way you have selected it to fall. And then all of these things, like remarriages and everything, sometimes creditor protections if it falls into an irrevocable trust. Those things come into play, and those things are really critical to preserving your legacy for your children.
Is Florida with intestate, is that the same thing as Georgia, or is that because you practice law in Florida too, right?
Well, I'm a Georgia attorney. I'm a Georgia and New York attorney. So Florida intestate. Yeah, I don't do estate planning in Florida.
But you have office down there, right?
Yeah, there we only do immigration law.
Okay,
so we only do federal law there.
Mm-hmm. How
we
about
have Florida
New York?
Lawyers down there, but
okay.
In New York we have a basically virtual practice for New York. So we help some New Yorkers, but through our virtual practice.
Is the intestate in New York similar to Georgia?
No. The surviving spouse let me answer your question. Florida, can't give Florida legal advice.
Understood.
But, intestacy is different in Florida, so the entire state would go to the surviving spouse, for instance.
Okay.
New York is a little different because New York actually allows for a marital share. So there's a portion of the estate that the spouse will automatically get. We just don't have that in Georgia.
Okay. But and this is the kind of stuff where, look, how would I get LegalZoom and stuff? And I'm not here to freaking, make sure that everyone hires Stephanie. I'm saying, how could LegalZoom know who you are if you're in? I literally, as we're talking, I got an email from a lady who just relocated from Maine to Asheville, North Carolina. And it's just like, and she's asking me, hey, do I know any attorneys or CPAs down there? Which is good, because I always say be proactive.
Yeah, you should talk to someone. Yeah.
But the issue is, if you are LegalZoom and you did the thing in New York, and now you're coming to Georgia, and you're like, I said, you have a will, and you're like, yeah. Well, if you didn't tell me that you relocated, it might not work the way you think it did, because where you had drawn it up change is different now than down here in Georgia. You know what I'm saying, Stephanie?
Right, exactly. And most of the time that a will is going to be honored when you move, but you absolutely, when you move, you'd want to check in with a local attorney, and just get it updated. It's not that expensive, and it's so important to just have everything updated. And not only that, in our practice, we really believe in making sure that we speak to a client at least every 2 years, get an update on their life. Life changes. If you have a 20-year-old will and the beneficiaries are no longer, let's say the beneficiary has grown up, was a minor child, and now that beneficiary has grown up and they like to spend a lot of money. Now, are you still thinking that you want to give them outright a $500,000 estate, right? Or larger in some cases? Maybe they can't manage their money and you want to help them through another vessel, or maybe just simply they're no longer living. Some beneficiaries may no longer be living. It is important, no matter where you're living. Certainly if you relocate, you need to talk to an attorney, a local attorney, and have them just evaluate your will and maybe update it. But every 2 years, just reach out. If you have an attorney that drafted your will, for us, we just do it. We do it as a matter of practice, free. We always, every 2 years, we look at the person's circumstances and their goals and make sure it still aligns with their estate plan. But just reach out to an attorney every couple of years and get that will updated. Read it yourself. Some people haven't taken their will out for 15 years and looked at it, and they don't even know what's in it. The other mistake is, of course,
I do. When people got living trust, they'll say, who's your successor trustee? And, someone has a trust usually knows a little bit more than someone just has the will in terms of what their estate planning is, because they got the trust for a specific reason, and no one knows. And I said, that's fine. You don't have to know. Let's bust it out. And then we'll bust out the trust. And we'll say the successor trustee is Uncle, we'll call him Uncle Jim. But Uncle Jim's got dementia now. I said, we probably need to update that, because if something were to happen and your Uncle Jim's co-trust or successor trustee, that ain't going to fly. You know what I'm saying? Didn't Georgia, like 10 years ago, change our laws for medical powers of attorney or something like that? What I know, Florida changed it, and Georgia. Both these states had some change in estate planning, in the last 10 years or so. Are you familiar with that by chance?
Yeah, we have a in Georgia we have a statutory advance directive for healthcare.
Yeah.
Real easy form, just designating somebody who is going to, be able to make decisions for you if you're incapacitated. Very fairly simple. But you have to do it, right? And you have to execute it properly. But it's available on a lot of websites. A lot of people will use those websites, but certainly we try to do it, in combination with your comprehensive estate plan. But it's called Advanced Directive for Healthcare. That was the change, and they updated the statutory form.
Yeah, but see what I'm saying? It's like with LegalZoom, I just feel like folks, I'm not trying to come across like a sales pitch. I'm telling you, LegalZoom is not going to reach out to you and say, hey, by the way, the laws have changed. And because Ford has something pretty significant too. And then, just going back to New York State, they just updated their estate tax law, the state estate tax law.
Right.
And no one's going to reach out to you from a computer program and say, hey, you got this money that's going to be subject to XYZ estate tax, XYZ in Pennsylvania. We got inheritance tax. New Jersey just had massive changes to their estate tax law, but they still have inheritance tax. No LegalZoom is going to talk to you. Now, with that said, Stephanie, I got to tell you, just because you hire an attorney to draw it up doesn't mean that attorney's as competent as like Stephanie would be here. Because I'll give you an example. I had these folks in South Jersey when I was working at Philly. And she thought she had and back then New Jersey you only had 675 that you could transfer without subject to the New Jersey estate tax. And this is only probably 8 years ago. Long story short, they thought they had an irrevocable trust set up, to avoid the estate tax. And if you looked at the first page of the flipping trust, it said this trust can be revoked by the grantor, and the grantor was them. And they had an attorney draw that up, and that is like it's kind of like in financial planning. We got a lot of bad financial planners out there. We have some good ones. We have a lot of bad ones. And unfortunately, the same thing goes to law. So somebody says, well, I don't trust any of those guys anyway. And it's just too bad because there are a lot of good attorneys out there. There are a lot of good financial planners. And if to throw them all in with some of these incompetent fools is, I just think it's putting yourself at, not you, Stephanie, but the listener here, at undue risk for sure. That's too bad.
Yeah, absolutely. I mean, that's the whole goal behind a revocable living trust is that you can revoke it, you can change the terms, and you can update it as you need to, because your needs are going to change throughout your lifetime.
Do you help so the big thing is an unfunded trust, and I've seen this a million times a Sunday, and that ticks me off. So someone comes to Stephanie's office and says, and you have the discussion and you find a trust is valid. Obviously, folks, if you're going to do a trust with an estate planning attorney, it's going to be a little bit more expensive. No getting around that, and just recognize that's the thing. I mean, literally, it's if you talk to a competent estate planning attorney who recommends a trust, a living trust, all right? And we talked about living trust before many times. We'll do it again. But that just is literally just you own it, you control it, the whole thing. It flows back to your 1040. It's part of your estate when you die. But if you go into Stephanie and she says, hey, I recommend a living trust because of whatever it is, and obviously she'll tell you why. Do you help them, put the assets in the trust, Stephanie, or what? I mean, because that can be a big problem with these unfunded trusts, I've found.
Yeah, we started the conversation talking about mistakes with estate planning. That's another huge mistake, is having either a trust that's not funded at all, or that is partially funded.
Yeah.
Because you have to fund a trust is useless if it's not funded. And by funding, all we mean is you're changing the title of the assets into the name of the revocable living trust. The Stephanie Scarborough Revocable Living Trust, my assets are now owned in that name. And that's what we do. And it's going to happen at your death, I should say. Somebody has to run around and do all of this. You're just doing it in advance, right? And that we do help people do that. We give people the option if they want us to do it. Obviously, they pay us to do it. Yep. But we do give them the option. If they want to do a self-funded trust, then we're probably going to harass them almost. We're going to call them and make sure they funded that trust. We have an asset and liability spreadsheet that we give them, where they can mark off what's been funded, and then we want to check back with them.
Oh, okay.
Sometimes
cool.
It takes them 2 or 3 months, but we want to see, hey, send us your updated spreadsheet.
That's fantastic.
Tell us what you funded into the name of the trust. And then we also want them to put that into their binder, the deeds or the bank statements and everything that they've transferred into the trust, into the binder, so that when we do meet with them in a year or two, depending on their circumstances, then we can see what's been funded.
Yeah.
And we can make recommendations. Even if they don't pay us to fund it, we want to follow up and make sure it is funded. And I can tell you, I have clients who haven't funded their trust, and they've come back to me because they didn't want to pay extra money. It's a lot of running around. It really is. For people who own a substantial amount of assets, there's a lot of work to be done, mostly administrative work. So we've had people who just couldn't get everything funded and just came back to us after 6 months or so and said, "Can I just pay you guys to do this?
Right.
Just do it." Right. And especially business owners who are already busy, they need help. Right. So
the last thing a business owner needs to be doing is going to the county courthouse to retitle their house in their living trust. I mean, I'm not saying, I'm just saying that at the end of the day, they have a business to run, get back to doing the things that you're good at. Let Stephanie do the things that, her team's good at for sure. I do find the lack of putting homes in trust is a big no-go on a lot of estate docs. And I'm not saying they needed to have it done, but in my opinion, who's better to do that? Stephanie and her team, or your attorney, folks. I don't care who it is. It could be your attorney or you.
Right, anyone.
I mean, do you really want to go down to? I'm just giving an example. I was trying to get my homestead exemption file, Stephanie, because even though I'm a financial planner, I'm an idiot. I did not file my homestead exemption for Fulton County for the first 5 years we lived here, and I knew to do it.
Yeah, it happens. It happens, right?
Because I dreaded going down. I said, I don't know. And so, long story short, I went to the wrong place, and she was actually quite nice. And then I had to go get this other paperwork. So it took me. It was a lot. I lucked out. I went at the right time. Well, it wasn't nearly as difficult as it could have been. But I was sitting there thinking, if I would have come at a different time, this could have taken a whole day, if not two. And the funny thing is, now that you just said they can hire you guys to do it, I was like, well, Stephanie and her team know exactly where to go. They know what courthouse to go to. Exactly. Where you're not. Just find it funny. Let's talk about. So we talk about will. We talk about living trust, healthcare directives, durable powers of attorney. Just your thoughts on just big IRA stuff, Stephanie, because going back to that grandkid, and we'll just pick on him for a little bit. If he gets a big fat IRA and he's 22 years old, that money is going to be, we know that money is going to be spent, and it's going to be taxed enormously because he'll take it as a distribution and have to pay ordinary income tax. Out, right? And we know this is not debatable. People say my grandkid wouldn't do that. Yes, he will, because like Stephanie said, when it comes to money, all of a sudden everyone's got lake houses in there or fast cars. Any thoughts on? I waver a little bit. I'm not an attorney, but just putting a trust as your beneficiary of a large IRA or 401k or something. Any thoughts on that?
Yeah, two things. First, life insurance and IRAs.
Yes, good point.
And
right
life
on.
insurance, if you have minor children or you have a special needs child or you have even what we call a spendthrift spouse, someone who's going to spend the money really quickly and you want to make sure that, you can control that a little bit, then I like life insurance trust, putting life insurance into its separate ILIT, what we call an ILIT for life insurance. And IRA, it really depends on, I usually reach out to the wealth advisor and say, is it reasonable? Because if there are options for the spouse to spread out the RMDs, then the wealth manager might say, name the spouse as the primary beneficiary, name the IRA trust as a secondary beneficiary so that the spouse can stretch out the RMDs. So we want to take advantage of those stretch out provisions in consultation with a wealth advisor, for instance. But really, almost always we'll list a trust as a secondary beneficiary on an IRA.
Yeah.
And I'm quite fond of that. I like trust just for, unless you have a perfect scenario where you know that the person is terrific at managing money, there's no external pressures, they don't have medical issues or special needs, then that risk is there for the individual. So I like IRA trust and I like life insurance trust.
Who do you recommend as like successor trustees, though? Because my own experience is when it's this again, I vacillate some, but my own experiences is Uncle Bob will be the successor trustee, but then his sister will want the money quicker than what Uncle Bob feels appropriate as by law from their parents. You see, not by law, but from dictate from the parents.
Mm-hmm.
And Uncle Bob's now getting hammered by the sister saying, give me the money. And he's like, man, I can't, because Dad was really worried about you, sniffing up your nose or something like that. What do you recommend?
Yeah, I mean,
yeah. Mm-hmm.
Yeah, I like that. I like to name a secondary corporate trustee, a financial trustee, someone who does this for a living. For one, I like to do it because the purpose of that money, I mean, you can really, tend that garden. A financial advisor and a professional trustee can work with a wealth advisor to really grow that money so that as you're taking the income, I mean, it might be that your beneficiaries are only taking the income from that trust, and you can preserve the principal for their children or for them as they go through life. And it's basically their own retirement plan, right? I mean, they have income that they're getting from the trust. The principal remains secure unless they can permissibly take it under the terms of the trust, and you set the terms. So I like to name a fiduciary, a corporate fiduciary, somebody who is a trust advisor and can manage the estate, because it helps the trustee, right? Like you said, Uncle Jim or whatever, he doesn't want the pressure, and he's more likely to cave than a professional advisor. A professional advisor can say no. And how about this? What if you have issues with Medicaid? So if you are a special needs person, or you have to go on a Medicaid,
right?
Let's say you have a stroke, your beneficiary has a stroke and has to get Medicaid, and I know we don't, you should pay what you're supposed to pay, but if the money can be used to make their life, more comfortable, then if it's in a trust and they can just take it what they want, as that money goes into their account, it's going to go to Medicaid, right? You can only take a certain amount out. If it's controlled the proper way, it can improve their housing situation, because let's face it, Medicaid doesn't pay for everything.
No.
So it can improve their housing situation, make sure they don't lose their home, put them in a more secure environment. So that money can be used in a trust if it's managed properly by a professional trustee. And sometimes if it's a special needs situation, or by a family member with some sort of guidance on how it would impact their Social Security or let's say SSI or Medicaid benefits. So there's a lot. It's a powerful tool for helping your family members, far into the future.
Absolutely. Now, do you act as trustee by chance? Stephanie's
we don't.
firm? Okay, gotcha.
No,
but
we don't.
Folks, fiduciary corporate trustees that you can recommend that you're comfortable with?
We do.
Okay.
Yeah, we do. Mm-hmm.
All right, good. That's always been an issue. Like, who should I hire as a trustee? For corporate, because that's not a cheap proposition. And I worked in banking a long time ago, and I remember some of the trustees at Old First Union Bank who weren't worth freaking 10 cents. You know what I'm saying? And I just said, oh boy. So you always want to make sure that you have somebody you can rely on, i.e., someone like Stephanie, who can kind of wash out the losers from the winners in there for sure.
Yeah, exactly. And you really have to keep an eye on it as well. You have being a co-trustee even is a huge responsibility, because you're a steward of that money.
And I read this guy he had written an article, and I used to subscribe to Trust and Estates magazine. I don't anymore just because I don't have time, but he was talking about there's a cottage industry of estates being sued, trustees being sued because of the beneficiaries feeling they weren't getting what they felt they're supposed to. And who wants to mess with that stuff? I mean, put that on the legal people who know what the heck they're doing. You don't want to be Uncle John or Uncle Bob or Aunt Mary or whatever, and you get sued by the beneficiary because she or he feels like he's not getting taken care of the way he should be. What a nightmare.
Right. It is a nightmare. It really is. And sometimes it's worth every penny what you pay a trust manager, because in the end, if they're managing the assets properly, their payment is coming out of whatever income may be grown by the trust, right? If they're doing it in the proper way, and they're working with a wealth advisor. So, and some of them are, by the way, wealth advisors as well. So if they're managing the asset properly, then it's going to be taken care of. And it's such a valuable asset to have. I should say that an irrevocable trust. So when a trust, a living trust, which is revocable, meaning I can change the terms during my lifetime, when I pass away, that trust in most circumstances becomes irrevocable.
Right.
The terms are set by what I said the terms were before I died. So an irrevocable trust that you set up for somebody else becomes a very valuable asset. And I should say it's not even a personal asset, but the reason I say that is it can be insulated from divorce, creditors, sometimes from bankruptcy.
Yeah.
It can be insulated from a lot of life circumstances that we face every day. That is like really critical, because I've had, I have a colleague who went through a personal bankruptcy, but her grandmother had gotten an irrevocable trust from her grandmother's estate, and that money was there for her, so she wasn't destitute and was able to start again and start fresh.
We used to
we
used to call it, Stephanie, that the trust will protect your heirs from creditors, predators, in-laws, and outlaws. And I always thought that was pretty funny, because exactly right. I mean, and I hate to say it, but a transfer on death or a payable on death arrangement won't do that for sure, because there's always going to be someone snooping around at the money. When
Yeah.
Lastly, just real quick, I've got to go to physical therapy because I had rotator cuff surgery. Yay! But I'll get out here in just a second. One more question, real quick. So let's just say someone hires. This is specific to your firm, and I just go back to my. I have a wife and 4 kids, and my oldest at Georgia Tech. My youngest are still children. I mean, they're all children, of course, but you know how it is.
Sure.
And when you got 3 teens. The nice thing about having an attorney that's local and present, that you can see the face as a human being, is what I say, Stephanie, is that if I get killed, my wife will know to go to our attorney. You know what I'm saying? And I imagine you would do the same thing. It's like, look, or if she gets killed, I say, I don't know what the hell to do. You know what I'm saying? To settle this stuff. What do I do? Well, I just go to the person who drew it up, which is Stephanie Scarborough's law firm. I'm just saying, look, I call up and I get Bailey on the horn. I said, Bailey, this is Josh Scanlon. My wife just died. I got some insurance. I got these kids. I don't know what to do. Can you help me? And I hate to put words in your mouth, but I imagine you and your team are going to get on that like white on rice to make sure that the burden is removed to some degree off the surviving spouse. Does that make sense, what I'm asking or stating there?
Absolutely. And that's the probate process if you don't have a living trust, and it's the probate process if you have a will or don't have a will. But it's if you have a living trust, there's still things that have to be done to transfer the asset.
Absolutely.
And by the way, how do I, just the fundamentals of getting access to the bank account, of doing those things, of making sure if you're incapacitated, the durable power of attorney is working, and just that's what we're here for. And that is really I don't want it to be a commercial again, because this is about educating people, and that's what we're here to do, is make sure people understand that whomever your advisor is, whether it's us or somebody else, make sure that you have a good relationship with them and you don't disappear for 5 years and not talk to them. When you walk in with your estate planning binder, or you even give me a call on a Saturday night at midnight and I get a message saying that something horrible has happened, I can look at your documents and know exactly what to do, and we can jump in and help. And that's really the key is support for our clients. So absolutely. And any attorney that you're working with who's kind of your personal family attorney should be able to do that.
Well, tell folks how they can get a hold of you, Stephanie, if you don't mind.
So you can get a hold of me at scarboroughlaw.com. You can also call our office at 678-257-1808. We're on social media also. You can reach out to me at Stephanie Scarborough on Instagram. That's my personal Instagram page if you want to see some of my great cycling adventures. And we're on Facebook at Scarborough Law, Georgia.
I'll put links in the show notes, and Stephanie has a YouTube channel, Stephanie Scarborough. I'll put links to the show notes that I've encouraged her to activate that more. She got 4 videos now, but one was actually pretty popular on the H4EAD. I don't have time to talk about it right now, but that was a very popular. So if you're someone who's interested in H4EAD, this is a place you'd want to check, because she had 26,000 views in the last 5 months' time, and Stephanie only has 3 other videos, which tells me there's a lot of information about H4EAD. But anyway, Steph, this is fantastic. Much obliged for you being on this call. Hang tight after we're just done, because I want to just say thank you offline here. So hold on just a second, okay?